strategies, and clinic experts Charles Wheeler and Michelle Sardone from the Catholic Legal Immigration Network. We're here to talk today about the final charge public rule, which is set to take effect next Tuesday, October 15th. The webinar is being recorded and all lines have been muted at this time. We will share the recording and the slides in the CCUSA members portal after the webinar. Also, you may want to download them from the handout feature in the GoToWebinars on the right part of your screen. Towards the end, we'll have a Q&A section, and we have allotted a significant portion of time for the Q&A. So we do want to hear from you. So just please use the chat box feature to send your questions, or use the raise your hand icon to let us know and open the line for you to speak. I'm going to go over our agenda briefly today, and then I'm going to turn it over to Clinic's Charles Wheeler. As I mentioned, there's a lot of time for questions, so please keep them handy for the end of our presentation, and we'll jump right into it now. So our agenda today will be talking about the public charge, giving a synopsis on the rule from Charles, an update on the pending litigation, and then programs that are not affected by the public charge, attempting to combat the chilling effect of this public charge rule, learning about case management, and then I will end with advocacy on what you can do, the stories you can type, the types of stories you can collect, things of in that regard. So we'll turn it over to Charles to talk about public charge.
Thanks, Chris. So where are we, and how did we get there? So I thought I'd start really from basics with what is public charge, and it's a ground of inadmissibility. What does that mean? So if you are applying to get a green card here in the United States, or perhaps even from the consulate abroad, you are subject to all the grounds of inadmissibility. Public charge has been on the books for, gosh, over 150 years. It is one of the grounds that is probably the most troublesome for low-income people. And now it will become much more difficult to overcome. Primarily affects family-based immigration. I say that because family-based is about 2/3, maybe even 3/4 of all those people who get their green card, who become permanent resident aliens. Other people, for example, asylees, refugees, they are not subject to public charge. People who get it through employment-based or other forms of humanitarian factors, they probably are subject to, or they will be subject to public charge ground of inadmissibility, but it really is not all that big a deal because they have been working here and have the job skills. It is going to be an issue. The standard is likely to become a public charge in the future, which is subject to a lot of different views as to how that's to be defined. In 1999, the Immigration Service defined public charge as a ground of inadmissibility and issued a federal registered notice, although that was not finalized in a regulation. That has been the standard that has been used for the last 20 years. And that is what will be changing with the new ground of inadmissibility, or the new definition. What happened is that the agency administration published a proposed rule back in October of last year, 60-day comment period, which ended middle of December of last year. And then finally in August of this year, they issued the final rule. They will also be publishing new forms that will go with that. We've been looking at various updated drafts of those forms. We haven't seen the big crucial final form yet. In terms of the changes, the public charge inadmissibility assessment, in the past, the standard has been likely to become primarily dependent on public benefits. And that, again, was the 1999 definition. And the Immigration Service then identified 3 public benefit programs. They are cash benefit programs. For example, there are temporary assistance to needy families, supplemental security income, and any kind of general relief or general assistance that the person received from the state. There was a fourth one as well for people who are institutionalized for long-term care. It's a Medicaid program. So those four have been on the books for quite a while in terms of the types of public benefits that the Immigration Service can look at and consider if the intending immigrant has been receiving them. You might be aware that non-permanent resident aliens are really excluded from access to those public benefit programs, except perhaps some state general relief, general assistance, or perhaps certain programs with Medicaid. But by and large, SSI, TANF is really off limits for intending immigrants. So what has happened is that the administration wants to change this rule or definition to be someone who is more likely than not to receive one or more of a longer list of public benefit programs for more than 12 months in the aggregate in any 36-month period. So they've come up with this new definition, more likely than not to receive, not to become primarily dependent, and also a much longer list that includes a lot of non-cash benefit programs. So much more expanded definition that would encompass or include a lot more people. The issue, though, is that the administration is turning to the statute, which also lays out 6 factors that can be considered. And it's using these 6 statutory factors to define them in much more narrow way or much more onerous way that is the most troubling part of this from an immigration practitioner standpoint. So you see on the next slide the focus on income from the intending immigrants aspect and the definition of these 6 factors, which I'll talk about in a minute. What has been going on for the last 20 years is that intending immigrants, people applying for adjustment of status here in the United States or people applying for immigrant visa abroad, have had to submit what's called an affidavit of support. This is the person, the U.S. citizen family member or permanent resident alien family member, becomes a sponsor, and they submit an affidavit of support. And for the last 20 years, all of the attention and focus has been on that person. Does that person have enough income, resources, evidence of tax returns, that they are going to support this intending immigrant, this family member, in the future? So that's where the focus has been, and that's where the focus will be taken away with this final rule. The focus is now going to be on the intending immigrant. So what has been up until now a fairly straightforward and almost standardized test to see whether the sponsor has enough income is now going to be turned into a multi-factored test with a lot of discretion given to adjudicators, State Department officers, to determine, in their opinion, whether negative factors outweigh positive factors and whether they want to use their authority and their discretion to deny someone is likely to become a public charge, when currently and in the past they have not exercised that authority, and they have simply looked to the sponsor. All right, so what are these 6 factors? You see them up there on the slide. Their age, health, family status, etc. And they have defined these in such a way that people who are under 18 are going to be automatically a negative factor. Anyone over 61, again, a negative factor. And even if you are between those ages, you're going to have to evidence an income of at least 125% of the poverty income guidelines based on the United States standard, not based on where you have been working or what country you're from. Health is going to be a much more of a focus in terms of any kind of conditions that might make it more difficult for you to earn a living here or to go to school. Family status simply means that they are going to be looking at all the family members who you're coming in with or who are part of your household to determine what the 125% of poverty measurement is going to look like. They are going to require that you have evidence of at least a high school diploma, that you have prior job skills, that you have a positive credit report, and that you are proficient in English, or at least you have evidenced English proficiency through certification of courses. So that's what is the most troubling to immigration practitioners, although the issue of public benefits is what is really driving the concern and a lot of the interest with a lot of other nonprofit agencies. So while public benefits receipt is certainly going to be a negative factor, most of the people who are applying for a green card or for an immigrant visa are not going to be eligible for the benefit programs that are affected. And on the next slide, you see the whole laundry list of programs. There are 9 of them that are what's called part of this totality of the circumstances test. In other words, they're going to ask you if you are currently or have been receiving any of these 9 programs. The first 4, as I mentioned, were already considered or could have been considered. It's the next 5 that are the new ones, with Medicaid, food stamps, and then these 3 housing programs being the most troubling ones. I know we're going to get into more detail in terms of describing these. For example, there's exceptions to the Medicaid that basically eat up everybody who is even eligible for Medicaid. And there are other things that I've skipped over in terms of the 6 factors, in terms of what that's, how that could be very troubling. I wanted to mention that there are 9 lawsuits that are challenging this public charge rule. And you see that on the screen where they are taking place. They're in 5 different jurisdictions, or actually I should say 6 really. And they have already had hearings on what's called preliminary injunction complaints and motions. There was several of these are consolidated, for example, in Maryland and New York and California. Some of these challenges have been consolidated. There was a hearing, for example, in New York on Monday in a lawsuit that Clinic is actually a named plaintiff on. There was also hearings the prior week in California with 3 of the lawsuits that are consolidated out here in San Francisco. And those hearings went very well. So we are, I guess you'd say, optimistic that at least one of these lawsuits is going to lead to a nationwide injunction. But we, at the same time, are also encouraging people to continue to file adjustment applications and take all caution in mind. So we'll get into that as well as we go forward. The basis for these challenges are similar in the sense that they're saying that the regulation violates the Administrative Procedures Act. It's what we call arbitrary and capricious, because the agency is not considering fully the effects on the immigrants or the detrimental harms to the country. They didn't appropriately address all of the comments that were raised, and most of you probably know that 250,000 people have commented, almost all negatively, to the proposed regulation. The laws are really, the rule here conflicts with congressional intent, legislative history. This really is sort of a circumvention of what Congress's power is to do. There's no real authority to do that. There's also Fifth Amendment claims as well as other federal laws, federal claims. So that's an introduction to where we are and how we got here. Let me turn it over now to Jane to talk a little bit more about the public benefits issues.
Just wanted to say a few things about some of the programs that aren't on the list, particularly for families with young children. I think it's important to recognize that there are still some programs there that they can tap into. Individuals who have children that are citizens can still apply for SNAP for their children, and that should not really reflect on the parent because the benefit is going to the child. Now, that might be a hard case to make with the family, but the benefit goes to the child who is a citizen and eligible for that program. Other programs that aren't on this list is WIC, Women, Infant, Children, that provides support to pregnant, postpartum, nursing mothers and children up to age 5. there is an income eligibility, and depending on the state, you might have to show some local residency, really just to connect you with the local WIC center. So that could be a real lifeline for families, particularly if one of the young children does not have legal residency. School feeding programs. I think it's always to your benefit to reach out to the school system and see how they run this in your area. If the school system is in a particular jurisdiction where 50% of the children attending that school are at free and reduced, they shouldn't have to collect information on that individual child. The school is eligible by virtue of where it's located. It's in a low-income neighborhood, or, you know, blended with enough individuals who are low income that it automatically qualifies. I think sometimes telling a parent that they have to register their child and put all their information down could be a detriment to them participating in the school lunch program. But in many instances, that isn't the case. Some communities have community eligibility, and so they're just, anyone in the school is eligible for breakfast or lunch, whatever the school offers, just by virtue of being in an impoverished neighborhood. So that would be something I think you should learn how what the school system is in your area, how they handle that, and encourage families to take a look at that. A lot of after-school programs, Catholic Charities runs a lot of these, tap into the child and adult care food program. Again, if your program is in a neighborhood that qualifies 50% free and reduced, you don't necessarily have to share the information of who's receiving that after-school snack or dinner with your state agency. You're giving a count. And similarly with summer feeding, that can be a real lifeline in the summer when school lunch isn't available. Where you position your school lunch program can determine if you have to qualify individual families or they just automatically are enrolled because of where the program is operating. Again, it's that 50% free and reduced is a real critical measure there. If you're interested in summer feeding, a lot of the state training will start early in the year, January, February. So think about that. If there's any support we can offer, I'd be happy to kind of connect you with your state agency or walk you through those programs. But I think that after school and summer feeding are programs Catholic Charities has a lot of experience in, but encouraging people to look at WIC, where they qualify, and the school systems as a way to take some of the burden off those families.
Thanks, Jane. I'll dovetail on that to talk about some of the chilling effect, the concerns. In particular, I want to just dovetail with Jane on working collectively with the state and local agencies who are administering the programs, making sure that everyone is on the same page of the information that is going out there. Jane talked a lot about the eligible individuals and families leaving programs out of fear. Despite eligibility, they're just telling providers, just get me out of this thing. It could affect my immigration status and applications later on down the road, despite their potential eligibility for programs. So I've already heard stories about that coming back from Catholic Charities annual gathering. A lot of people scared about just get me out of it without kind of consulting anyone who is working on the programs. So that is a concern about public charge that everyone on the front lines will be facing. Another big concern, again, I heard about is misinformation, as you can expect, in particular to Catholic Charities. One of the concerns that was raised was that in the community, at least in one particular area, the rumor was, don't go to Catholic Charities because they are providing public charge. Something along those lines, where administering programs or helping people with programs, the rumor mill starting that just don't get involved with Catholic Charities at all. Again, I stress that was just one concern that I heard in one area of the country, but it will obviously have a chilling effect on programs that people are eligible for, could receive assistance. And so that is something of concern for everyone involved with programs and providing legal services. Also anticipate, because of the chilling effect with these programs, these federal programs, the increase in demand for private resources such as food pantries. So once someone leaves programs out of their concerns, whether they're accurate or not, there is potentially going to be an uptick in private resources such as food pantries. So just because people are not using the programs doesn't mean that they'll suddenly be able to provide for their families. So private food pantries at churches or Catholic Charities agencies, it should be expected that an uptick in the demand for those private resources is going to go up. So with those chilling effect concerns in mind, I'm going to turn it over to Michelle to talk about how you should be counseling clients in this environment.
Thanks, Chris, and thanks everyone for being on today's webinar. Just quickly wanted to run through a few points when you're interacting with clients, especially those members of your team that are in immigration legal services, and then those that may be providing social services, but to some of your immigration clients. And the first and most important is if there's any way to push those cases through that you might have sitting on your desk, or that you know someone right now is eligible to apply for a green card, to get those applications in before October 15th. I know that Charles earlier spoke about potential litigation, but we haven't heard anything yet that is stopping this rule from being implemented. So to please try and get as many of those cases that you have and know about into as right now. And then you should also kind of warn clients that there is pending litigation, but that nothing is enjoined yet, that there haven't been any change. There hasn't been anything to stop the changes from happening. The third point on this list is about assuming that the Department of State will incorporate this final rule. So a lot of what we've been talking about are for those individuals that are applying for their green card here within the United States. And there hasn't, although there have been earlier changes, the changes that we're currently talking about today, it takes months for you to put together paperwork sometimes when you're working with family members that are here in the U.S. that are applying for family members abroad. So to really think about asking for as much paperwork now in case those cases need to be submitted after the final public charge rule goes into effect. Even though we don't have an approved form yet, as Charles mentioned, it will be important to start gathering those documents, to be asking clients about, their health insurance and their credit report and their back taxes, ask questions that you may not have asked about before, but you will need to potentially be asking about with the new form. And then most importantly is this last point about doing community education and outreach about not disenrolling from benefits without counseling. And so to make sure that both of your teams, those that are working on immigration legal services, as well as all people on your staff that are doing immigration legal, that are doing social services to immigrants, to the general public, that you're really partnering on this, is going to be super important. So on the next slide, it talks a little bit about how you might prioritize the cases that you currently have. So if you have a lot of cases that are eligible that you could be submitting for those that are applying for a green card, and you may have too many to get in the next week, to make sure that you're prioritizing the most vulnerable cases. And that's a decision that you will need to make as an agency. Who is the most vulnerable? Is it the one who, looking at it, may be really difficult to come up with additional documentation, to really sit down with your team and to figure out who the most vulnerable is and to get those cases in as soon as possible. You want to be out there in the community doing those joint presentations, those who are experts on local public benefits. It really is important to be local because we can talk about kind of benefits in the large sense, but they're going to be super specific because there may be benefits that are offered in your city or state that aren't offered in other places. And so people will have specific questions about the programs that are offered in your area. So to make sure that you're doing joint presentations with the Immigration Legal Services and those experts on the benefits. And then you should be planning for what happens after October 15th if there is not an injunction. So what is your capacity to do these cases that will involve more work? So who haven't you helped that are now subject to the new rule? Perhaps there are clients that you've had initial consultation with from your Immigration Legal Services team, but you haven't yet moved forward with the case. So you may have had an initial conversation and you have to do follow-up now to make sure that they bring additional documentation in. And then you want to make sure that you're updating your legal services fees to reflect the additional time that you will be taking to do these cases, because now you're going to have to add a lot more questions to your intake sheet to figure out if someone is eligible or not. You're going to have to analyze all of the documentation and the information that your clients give you before submitting the application. And then you're going to have to prepare the application for filing. Not only will there be a new application that you'll have to submit, but a lot of accompanying documentation that you'll have to gather and organize and include with a cover page that you want to make sure that you are assessing your time appropriately. And then on the next slide, I just want to talk a little bit about, tracking your work. So you want to track what is happening. I'm sure most of you have already been kind of seeing what's already been happening with your social services, but after next week, if the final rule is implemented, for you to be able to track whether or not there's a decrease in the number of immigration legal services as well as your social services, if that has an impact on the income that you're seeing from your immigration legal services, or if there's the same amount of people but the number of hours that you're spending on these cases, that you're really tracking that and making program decisions based on that. And you may need to secure new or different forms of funding for the program to do this additional work and to start thinking about what the local funders in your area may be when you talk about public charge, how, most of your programs are doing holistic services where you're doing this immigration legal services where that will be a huge impact, but you're also doing the social services that will see lots of changes as well. And so what funders in your area may likely be able to give you support to help with the increased work. And then to think about, maybe there are other program considerations that I haven't talked about that may be specific to your agency. So to really think about that. And then Clinic has a survey just as we're creating resources for programs that may be helpful in this public charge and during this implementation phase. And also if you have any questions about the implementation that we can pull together for clarification from U.S. Citizenship and Immigration Services, the link is here on this slide. And now I'll turn it back over to Chris.
All right, thank you, Michelle. I work on the advocacy team and wanted to just bring it back here. Although the final rule is obviously set to take effect next week, there are resources available to get the word out on how this is going to affect communities and basic information that you should know. So with the existing resources, I'll start with our backgrounder. I included the link on the Justice for Immigrants page that kind of goes over in detail what exactly the programs are, why this matters to the Catholic community, and things of that nature. So that is available for you, and if you're doing any advocacy work in the community. Other resources, the USCCB has the Justice for Immigrants page. If you look for that, that has additional resources on their comments on public comments on the public charge rule and other resources that you can review. And cannot stress enough, Clinic with our colleagues on the phone, they have excellent resources for you on this issue that are updated regularly.
Chris, could I just give the website for that? It's cliniclegal.org/public-charge.
Okay, great. So compiled in one central location for Clinic resources on this issue. So please consult that, particularly with injunctions possibly occurring in the next few days with the cases that Charles went over. Please keep checking back and leading up to the effective date for this. As far as what you can do going forward with advocacy, taking information in and providing it to advocacy teams through JFI, USCCB, Clinic, and CCUSA, really helping us understand how is this new rule affecting your communities? What are you seeing in there? And then compiling persuasive individual case stories. They're probably going to be sad, but policymakers, decision makers, they won't know about it unless we hear about it in the local communities and if it bubbles up to here in Congress as well. So gathering them and getting them to people who are advocating to explain why this public charge rule isn't good for our communities, isn't good for immigrants. Gathering those stories is really critical. And then compiling policy outcomes of any data that you guys are seeing of an influx of, as I mentioned previously on one of the slides, about the demand for food in pantries and things like that compared to what it was beforehand without the public charge rule. Understanding what those numbers are and being able to provide it again to advocates is critical, so we can make the most compelling argument for the decision makers. The other thing going forward, which is probably the most positive thing we can do, is Jane mentioned there are programs that aren't affected by this. And because of that, we can advocate for more funding so it covers more people in those non-affected programs. So advocating for the programs and seeking additional funds so we can cover more people. I also wanted to stress before we head on to questions of, we deliberately tried to combine immigration legal folks with social service providers and working together. And so in the advocacy, we had an event this week in DC where I got to speak to a California Department of Social Services representative. And my question to her was, in the event that someone comes to Catholic Charities or some type of assistance agency, they're an immigrant and they're going to need both immigration help and social service assistance. Who should they go to first? Because the public charge rule is going to affect both areas. And so her recommendation was, number one, work with your locals to make sure that everyone is on the same page with the programs. But then also, if you are new to public benefits and haven't used them before, talk to the legal team first, because the application is something that should be reviewed with an immigration attorney or an immigration representative at a Catholic Charities agency first. And so that's kind of what I wanted to dovetail before we get into questions, why we wanted this presentation to take place and who we catered the audience to make sure everyone is working symbiotically between the legal teams and the social service providers. So with that, I am going to start it off with some questions, and then we'll open it up to the floor. I think the first one that I got, Charles, I'll kick it to you. Is it legal to use public charge as a reason to deny citizenship to otherwise eligible individuals?
That's a great question. We get that question a lot. So citizenship is a whole different animal. Those are people who are permanent resident aliens. In other words, they've already gone through the grounds of inadmissibility, have been found not to be a public charge, and then either 5 or sometimes 3 years later, they can apply for naturalization. So if you are in the process of applying for naturalization, public charge is not a ground of inadmissibility. It's not a ground that would keep you from becoming a citizen. So that's the good news there. That does not mean that all permanent resident aliens are forever free of being found a public charge. For example, when they leave the United States and stay abroad for more than 6 months, they will be subject to public charge when they come back into the United States. But at least at the naturalization stage, they're not affected by it.
Okay, thank you, Charles. The other one, I'll just open up to all the panelists because this is another common question we've seen. People who are scheduled to renew their SNAP benefits after October 15th, will they be seen as a public charge? So I don't know who wants to jump in first, but after October 15th and SNAP benefits.
Well, if they're eligible for SNAP now as an individual, unless they're, as Charles mentioned, there's a lot of other factors they're looking at, your household composition, the number of kids you have, all of that. But if they are eligible, they have some status in the U.S., a lot of families will apply for SNAP on behalf of one parent and their children. So that is still perfectly fine. The way we read public charge, the benefit is going to those eligible. So even if the mother has to apply on behalf of her children and she is not eligible, the benefit is going to the children. So it really would depend on the circumstances of the family.
Charles and Michelle, anything to add to that?
No, I think that's great. I think that you also have to look at this 36-month period, and the 12 months doesn't really begin until October 15th for purposes of new public benefit programs that are being considered. So I think there's a little bit of a gap there in terms of when that 12-month period, first 12-month period is even going to run. It's going to be October of 2020 before they can really assess whether, in fact, you have received benefits during that period. The other thing, though, is really to emphasize what Jane talked about, which is it's not all about public benefits. You've got all these other factors, and low income is going to be one of the most important factors.
All right, thanks. Next question we have is the evaluation of an applicant's financial status based on potential to earn income above 125% of the federal poverty line, or are they supposed to be earning that amount in U.S. dollars in their native country?
So that's also a very good question. Right now, and up until October 15th, as I mentioned, the emphasis is on the sponsor and their ability to show that for this tax year, for example, 2019, they will have enough income, they will be earning enough to support the intending immigrant at 125% of the poverty income guidelines. What the public charge rule, though, does, it looks to the current income and past income of the intending immigrant. So the adjustment of status applicant who is already here in the United States will be showing with past income tax returns, with wage statements, that he or she has been earning enough money to support themselves right now. So it's not so much prospective as much as retrospective. For people who are outside the United States, it's a much more serious problem because, as you mentioned, they have to show that they're earning equivalent amount as if they were in the United States and subject to the 125% of the poverty income guidelines for this country. So it's a much more difficult task for somebody, let's say, in Mexico or Honduras to show that they are earning the equivalent of U.S. dollars at a level at federal poverty income guidelines.
Okay, thank you, Charles. I'm going to give an easy one for Michelle, just if you could repeat, and I apologize for not including it in the slide, but Michelle, you mentioned Clinic's website on the public charge resources.
Sure.
Can you just say that one more time?
Yeah, and I think Fanny sent it out in the chat box to everyone, but it's cliniclegal.org/public-charge. And it has all of our materials, including some recorded webinars that we really got into the details about the changes.
Okay, thanks, Michelle.
Sure.
The next one I'm going to pose, but we may need additional information. So the question is this only for children that are American citizens? I'm going to maybe take the first stab at that and say every applicant, the focus is on the applicant with public charge, and that if they are U.S. American citizens, then they wouldn't be applying for immigration benefits. So I'll start that off for the panel. Just if I'm misreading that question, that came from Lisa. If I'm misreading your question, please let me know. But I think the question to the panel: children that are American U.S. citizens, how does public charge affect them?
All right, so I'll jump in here. The rule is very specific in saying that receipt of public benefits by family members who are not applying for a green card will not be affected. So in most cases, you have, let's say, a mother or father who's applying for a green card, and receipt of public benefits, SNAP, Medicaid, you name it, by that U.S. citizen children will not be counted against the intending immigrant. So that's sort of the good news. I keep returning to this issue, though, that doesn't mean that this mother or father doesn't have a problem, because usually it reflects low income. It may reflect other problems that are addressed in that 5 factors, statutory factors that are going to be considered.
Okay, thank you, Charles. Next question is a form question. If we are filing the I-45 application after the 15th of October, are we to file the I-94 even if the forms are not done? Yes,
in the sense that the 944 will be a required part of the application process. And you're quite correct, we don't have a final version of that yet. But the I-485 will be a new form as well. So there's 2 forms that we're waiting for finalization of, neither one of which we can access at this moment. I frankly don't think that will be a problem. I think that the agency is gearing up and will issue final forms by that date. So much as I want to stick my neck out, I think the bigger issue is whether this whole thing is going to be enjoined before that date.
Okay, another question for Charles. So the benefits will not be counted against the immigrant when adjusting status. Is that correct?
Okay, let's back up. Everyone who's applying for adjustment of status is subject to all grounds of inadmissibility, including public charge, if the application was postmarked by October 14th, on or before October 14th, then the old, or let's just say the current public charge standard will be used. If it's postmarked after that, then, assuming it's not enjoined, then the new final federal rule, public charge definition will go into effect at that point. So it affects both adjustment of status applicants as well as consular processing immigrant visa applicants on or after October 15th, depending on the date the application was filed.
Okay. I'm just going to skip around just because a new one came up. Do we know the fee yet, Charles, for the I-944?
Oh, there's no additional fee for that form.
Okay, thank you. Next question, if the client is working because he has an EAD card, employment authorization document, not on food stamps or any other government assistance, and files the I-45 after October 15th, will the client have to file the I-944?
Yes, all applicants on or after October 15th are going to have to file the new 944 form. If they are applying, if they're subject to public charge, they're going to have to file the 944. It doesn't matter if they have sufficient income or don't have sufficient income, all people will be filing the 944. And this affects both family-based as well as employment-based applicants.
Thank you, Charles. I believe we addressed this one before, but again, does the public charge only affect people applying for green cards, or does this include citizenship applications?
It does not include citizenship applications. It does, to some extent, affect tourist applicants in the sense that they will also be subject to a little bit more heightened standard for showing that they're not likely to become a public charge. It also affects people who have entered the United States as non-immigrants, students, tourists, whatever. If they are seeking an extension or a change of status, then they are going to have to show that they have not received any public benefits during that 12-month period.
Okay, that was the last question that we've received at the moment. We'll give people a little bit more time. If you have one, please type it in. Any other comments just while we're waiting from the panel on anything else while we're waiting? Just a quick reminder that everyone should be able to find the PowerPoint slides in PDF form in the right-hand column that Fanny has pointed out. And also want to emphasize again that this has been recorded for your benefit. Okay, a couple more questions. Oops. Okay, another further update for the litigation. Do we know at what step the litigation is at for a possible injunction? Again, Charles, October 15th next week. Where are we with the legislation?
Well, the two courts that are most likely to issue a decision this week are the San Francisco court, which dealt with the 3 of the cases out here, consolidated them. We're expecting a decision this week on that. We're also expecting a decision from the court in New York City, where that hearing took place on Monday. So again, guardedly optimistic that we're going to have a decision in the next couple of days enjoining. Question, I guess, is going to be, to what extent do those courts feel that they can issue a nationwide injunction versus one that only addresses the plaintiffs, or let's say the jurisdiction in which they are located. So, for example, out here we're in the 9th Circuit, which has a lot of states involved. New York is in the 2nd Circuit. We are hoping that there isn't some sort of patchwork decisions throughout the country that would create a lot of confusion, so that people, depending upon where they are applying or where they're residing, would be subject to different public charge rules.
And putting Michelle potentially on the spot, apologize if I am, but just I imagine clinic probably with some type of rapid response ready, given that October 15th is so close with your website page. Anything to comment on there for, you know, if an injunction is reached, how people will find out about that?
Yeah, so when there is any kind of alert, what we do is we send it out to everyone that has signed up for agency updates. So most of our affiliates are on that list, and all of the Catholic Charities agencies that are doing immigration legal services are part of that. So definitely your immigration legal services team will hear from us as soon as there is anything. But I would also, besides checking the website, I would, social media is really probably the quickest way that you would be able to find out when we have something up on the website if there's any changes in litigation.
Thanks, Michelle. A couple
Sure.
more questions came in. Can you explain the 36 months versus the 12 months again? So I think this is the aggregate issue with public charge, Charles.
It's interesting that you raised that question, because this judge who's hearing this in California had the same kind of puzzlement. Like, why did the administration pick 12 months and 36 months, and how did they come up with that? And the attorney for the government couldn't give a rational answer. So, in any event, the standard will be, under the new rule, you're going to look at a 12-month period during any of the prior 36 months to determine whether during that 12-month period the applicant received any of these 9 programs. And receipt for 1 month of 2 programs equals 2 months. So that's what they're doing. I can't explain how they came up with that, but they're going to look for during a 3-year window. And that 3-year window doesn't begin until October 15th of this year for 5 of those 9 programs. So the 12-month window, of course, doesn't even run until 12 months beginning in October 15th of this year.
All right, thank you. Another question. Every client, regardless of whether they receive public assistance or not, must file, I believe they meant the I94 Form. Is that true, Charles?
Every person who's subject to public charge, most green card applicants are subject to public charge, but some are not. As I mentioned, refugees, asylees, U visas, T visas, other people might not be subject to it, but most of our clients are subject to public charge, and beginning October 15th, they will need to file the I94 Form if the federal rule is not enjoined.
Okay. Next question. If a lawful permanent resident has been in the country for less than 10 years and receives a public benefit, will they be affected by this change, the public charge rule?
Well, if that permanent resident alien leaves the United States for more than 180 days, they will be subject to the grounds of inadmissibility when they seek re-entry, which means if they are currently receiving one of these benefit programs, they could count that against the person. And so, yes, they might be subject to what's called deportation proceedings, or removal proceedings, to say that they have become a public charge. Otherwise, if they're simply a permanent resident alien who's applying for naturalization, as I mentioned, or not even subject to leaving the United States, they're not subject to any kind of adverse action at this moment.
Thank you. Maybe hoping for a bit of optimism, Charles, you alluded to the litigation with the judge having some questions and the oral arguments you heard already. Are you hopeful that litigation will result in a delayed implementation or postponement of the October 15th deadline?
I am, and I think the numbers are on my side. When you have 9 court cases and 5 judges looking at this, all you really need is to have one of them say, yes, this sounds unfair and this sounds like an overreach. The fact that this is such a tectonic shift in the way we have years in the past means that courts are going to be looking at this closely to see whether this agency really has the power to go beyond legislative intent, congressional history, and we've got 200 years of history to look at. So the judge in New York, for example, spent quite a bit of time grilling the government as to where they can point to any kind of history in the past showing that public charge has been interpreted this way. Public charge, I should say, back in the 1800s and even early 1900s, was used as a way to exclude people who were going to be completely dependent on the state or colony back in the 1700s for their support, housing, food, etc. And now the government is saying simply likely to receive it in the future. Any kind of, a lot of U.S. citizens receive public benefits. That doesn't make them hopelessly dependent and primarily dependent on the government. So if you're receiving food stamps, if you're receiving a Medicaid benefit, does that mean you are someone who should be excluded from the United States when so many citizens receive it? So a lot of great policy questions were raised, and frankly, I think that the court is going to rule in favor of enjoining this rule.
Okay, thank you, Charles. Optimism is good. I do want to just make the point that we still got about a half hour left of time allotted, but we do have a lot of questions to get to. So at least for right now, at the time being, we're going to leave the lines closed, and if everyone can type in their questions rather than opening them for speaking, just so we can get to as many as possible, please type in your questions at this time. Next question, if you have submitted the I-864 already to the Department of State and are waiting for their review, will you then need to submit the I-94 after October 15th?
I wish I knew the answer to that. We are still waiting for the State Department to rule in terms of how and when they are going to implement this new federal rule, this new USCIS DHS rule. Most people realize that the State Department is a completely separate entity, and yet it usually walks in lockstep with the Immigration Service on issues such as public charge and other grounds of inadmissibility, just so there isn't competing agencies with different interpretations. In the past, what has happened when the USCIS issues a regulation, State Department issues a cable or changes what they consider their instructions for adjudicators, called the Foreign Affairs Manual, and that updates how consular officers should be interpreting this rule. So we are anticipating that the State Department, probably on or before October 15th, is going to issue some sort of notice, perhaps in a cable format, to all its consular officers, instructing them as to how to interpret this. The short answer to your question, though, is filing the I-864 is probably not going to be the critical form. It's probably going to be what's called the DS-260, which is the application for an immigrant visa. If logic were to prevail, you would say, well, if you're filing the application for adjustment of status on or after October 15th, then the parallel form with the consulates, the immigrant visa application, would be the critical one, and that would have to be filed before October 15th in order for the current rule to be in effect.
Okay. We have a request for evidence, an RFE question, I think, Charles. Can we file the I-45 without the medical exam so as to have the packet in before the October 15th deadline?
Absolutely. In fact, we encourage you to file the 485 packet without the medical form, simply because the medical form has a certain life to it, lifespan. And what we're seeing now is the interviews scheduled based on that adjustment application well after that medical exam has already expired. So we don't advise you to file the medical. That hasn't been a requirement for several years now. It's required at the time of the interview, or it's required to be sent in if the National Benefits Center is going to be adjudicating the I-485 on its own without an interview. But definitely don't let the medical exam stop you from filing for adjustment of status.
All right. This rule is a renewal question for green cards. Is this rule going to affect clients who are trying to renew their green card?
No, it will not. Green card renewal is based on other issues as to whether you've become deportable, for example. And what we're talking about now is a ground of inadmissibility. So that's not affected by green card renewals.
And then a follow-up to that, Charles, I think, this is from Carissa, clarification on the petition filed before October 15th. Will the public charge affect them?
Well, let's make sure we understand the terminology. Usually petitions are filed by U.S. citizens or permanent resident aliens. Let's say petition would start the process of immigrating a spouse or another family member. It's not the filing of that petition that affects the grounds of inadmissibility. It's the filing, in this case, of the application for adjustment of status. So the I-130 petition, for example, sometimes is filed with the adjustment of status, but oftentimes it's filed well before that. So the filing of the petition is not the critical date or the form, it's the application for adjustment of status.
Okay. I will take the next one on congressional action, whether there's possibility on public charge or appropriations to help with the increased demand for food resources. Yes, in terms of what's in the budget and things of that nature, but specifically to public charge, that really is in the regulatory realm. But the demand for food resources, those are all programs that could be debated, but I'm not surprising anyone with congressional inaction on pretty much everything, not only because of the divided Congress, but also because it is an election year. But budgetary items, that is something that is going to be reviewed. But beyond that, I would not hope for congressional action on anything too much, just because of where we are here in D.C. Next, for lawful permanent residents currently receiving public benefits, should they be advised to terminate their benefit?
And the short answer is no. Again, it's the departure from the United States for more than 180 days that would create a potential problem for permanent resident aliens who are currently receiving benefits. Ground of inadmissibility does not affect people who are simply here in the United States already as permanent residents. There is a separate ground of deportability, and the administration is talking about changing that, but I don't want to confuse anybody. That has not changed, and until and unless it does, I'd rather not talk about how permanent residents currently receiving benefits who are not planning to leave. The short answer right now is they should continue to receive those benefits.
Okay. Charles, again, do you suggest filing the I-485 before October 15th, even that there are litigation is going on? Is it still best to file the I-485 before the deadline?
I would say so. I think if you have the information you need to complete the application, got the documents, you might have to work this weekend and get it all done. But I would still say that we should probably be hearing from the court this week, which gives you the weekend or the Monday, Tuesday, if you only got a handful of cases you're talking about. But definitely get something in by the 15th, before the 15th, if you haven't heard any court orders yet.
Okay. I think this is a consular processing question and a FAM question. Hasn't the Department of State technically already implemented stricter guidance about public charge back in 2018? Yet outside the Florida consulate, we have not seen much stricter adjudication and discretion. Let's see, and discretion. Charles, how about those?
That's true. In January 2018, the State Department changed the Foreign Affairs Manual. In other words, their interpretation of public charge. I think really to sort of anticipate the changes that the USCIS was going to publish. So they got a little bit ahead of themselves. They have not, in fact, implemented that in a worldwide way because they're hoping that the final rule from DHS would take place. They're hoping that this new form would be pre-screened by the State Department before it is sent to the consulates. So most of the consulates have largely been ignoring that Foreign Affairs Manual change. The one consulate, unfortunately, that has not ignored it has been, in fact, very aggressively enforcing it is Juarez. But not so much by looking at the 5 factors as much as looking at the sponsor and looking at any other household members who are joint sponsors and being very critical as to whether the joint sponsor has the means and the intention to, in fact, support this person. So that's where we're seeing most of the action.
Okay, next question on the diversity visa winners. Are they subject to the public charge rule?
They are. Most of the DV lottery winners are abroad, and they are subject to public charge. And they have to show, in order to be eligible for the DV lottery, that they have a certain amount of education and work skills. So it already pre-screens some of those applicants. We haven't seen DV lottery winners be a real serious problem in terms of meeting public charge. There's no affidavit of support requirement, for example. But this could become a more serious problem for DV winners, as well as and we haven't talked about this at all, but the proclamation demanding that every applicant show that they have health insurance, this new presidential proclamation, that would come down very hard on DV lottery winners as well.
All right, thank you again, Charles. Give it just a couple minutes again. If you haven't written in your question, we've got about 20 minutes left or so in the allotted time. So please write in your questions. If there are no more written questions, we'll open up the lines. But again, so we can get to as many as possible, please write them in so we can answer them and have an idea to gauge our time. So one more coming up. If an undocumented parent accesses public benefits for their U.S. citizen children, this will affect them after they try to adjust their status through their U.S. citizen children.
Well, it's a little bit more complicated than, will it affect them or won't it affect them? The public benefits receipt by the U.S. citizen child will not be counted against the parent when the parent applies for either adjustment of status or consular processing in and of itself. But again, you have to look at the whole picture and see whether that parent has the income, has the work skills, has the education, etc. So depending upon the public benefit program, it might indicate that that family household size is such that if they qualify for public benefits, then they don't have at least 125% of the poverty income guidelines. But again, that depends on the benefit and the state and all that.
Okay, another follow-up from Carissa. During the adjustment of status, can the petitioner add another sponsor for the affidavit of support?
All right, so the petitioner, and again, I'm having to fall back on semantics here. Petitioner is the U.S. citizen or permanent resident alien. The applicant is the person who they're seeking to immigrate. And that applicant for adjustment of status is either a child or a spouse or maybe a brother or sister. The sponsor, though, is the petitioner. And that petitioner, if he or she doesn't have sufficient income, can get what's called a joint sponsor. And that joint sponsor has to be either a U.S. citizen or permanent resident alien, domiciled here in the U.S. over 18, and who does have sufficient income to meet that 125% requirement. What the final rule says is that the agency can look harder at this joint sponsor to see whether, in fact, they do have the income and the means and the intention to support the applicant. So we're going to see a lot more focus, which, as I mentioned, we're already seeing from this consulate in Juarez, focus on these joint sponsors. If they are not family members, if they are not living with the applicant, then it's going to be a little bit more problematic, I think.
Okay, another call, just please type them in so we can, again, gauge. We'll give it just another minute or so, and then if there are no written questions, we will open up the lines. While that's going on, I'll thank all the panelists, but in particular, Charles, we really appreciate kind of the rapid fire here. Thank you so much for answering everyone's questions. We really appreciate it. Okay, next one is refugee cash assistance included in the public charge.
Well, first of all, refugees are not subject to public charge or asylees. So RCA is not a benefit program that would affect the person. If, in fact, for whatever reason, they're years down the road, they decide that they would rather seek permanent residence based on a family member who's petitioning for them rather than the automatic 1 year application, then in theory, benefits received during the 12-month window, during any 36-month period, would count against them. But refugee cash assistance, again, is not part of the 9 programs that have been identified. So, short answer, it's not going to affect them.
Yeah, that's an important point, Charles. Just to stress again, I'm sure Clinics Resources emphasize this as well. Our backgrounder, who this rule doesn't affect, those are important questions to ask. The backgrounder does answer that. Refugees, asylees being the biggest ones, just to mention that. All right, it's now 3:15. Just give a little bit, another 10, 15 seconds or so. Otherwise, we will close down the questions. Okay. Thank you, everyone, for taking part. I want to thank our panelists again. I really appreciate the information. Oh, sorry. We got a new one. Will the new I94 form be asking questions regarding financial questions regarding specifically in the U.S., or will they be expected to show taxes and credit reports from their home countries?
Well, the 944 as written now is really focused on people here in the United States, but it does mention foreign tax returns, for example. So I assume it's going to be used by the State Department as well. So when it asks for income, it's talking about not only income that they've received in the past here in the U.S., but theoretically any income abroad as well. I don't see State Department coming up with any kind of parallel form. I would assume that they're going to be adopting this 944 for their own purposes as well.
Okay. How about an example, Charles? One of the new programs is non-emergency Medicaid. What would be an example of an exemption for Medicaid?
Well, the exemptions include any child under 18, any kind of school-related, pregnancy-related. So, again, most of the people who are eligible, who are non-citizens, are also subject to one of these important exemptions.
Okay, and then if the spouse of an adjustment of status is a U.S. citizen and they receive medical, I believe medical care, can the intending immigrant be charged as a public charge?
Well, there's two issues. One is the type of medical care that the spouse, the U.S. citizen, is receiving. So that's one thing you might want to look at. A lot of programs are not called Medicaid. They're called, health this, health that, whatever. So it's hard to determine from the name of the program whether or not it's a Medicaid program. But the short answer, again, is that any kind of benefits received by a U.S. citizen or other family member who is not applying for a green card will not be considered. So the short answer is the U.S. citizen spouse can receive any kind of benefit he or she is eligible for without it directly affecting. Income is such that it's so low that they do qualify for a lot of public benefits. Chances are the applicant is going to be have a difficult time showing that their income is at or above 125%.
Okay, one more question. Is student financial aid a possible problem for intending immigrants? In parentheses, not sure how many intending immigrants qualify for student financial, but I think some states are a little more progressive on this issue.
I'm not aware of any kind of federal eligibility for any kind of federal loan or grant. I don't know about various state programs, but again, that's not one of the 9 programs that's been identified and should not be factored in any kind of totality of circumstances test.
Okay. Social Security number question. Applicants who previously had a valid Social Security number, they applied under late amnesty and have credit hours, are they still subject to the public charge?
They are subject to public charge if they have a valid account and they have what's called 40 qualifying quarters, or basically 10 years of work history. Then they can use that in lieu of having to submit this affidavit of support. But that still doesn't mean that they're not subject to public charge. So they would need a 944, and they'd have to be subject to these 5 standards, 5 factors.
Okay, another broad question for the consulates. At the consulates, family members' use of benefits, is it counted against them? Is that correct?
Well, the FAM change in 2018 allows the consulates to ask questions regarding not only the applicant, but any family members' receipt of benefits. That's actually broader than what the DHS final rule is, of course. And we are seeing some consulates ask questions about that, but it's not on the form. It's not on the application for an immigrant visa. It would have to be asked affirmatively or by the consular officer, and there'd have to be some sort of reason as to why they're asking that. Most consular officers are too busy to start doing fishing expeditions to try to find out if there's any other issues that they want to raise. So again, it depends on the consulate, depends on the consular officer, but yes, they could ask questions about the other family members' receipt of benefits.
Okay, any last questions before we wrap up? Okay, I really want to thank Charles and Michelle, the Catholic Legal Immigration Network Clinic, being on rapid fire here with your questions. Thank you so much. For our legal service providers and our social service providers, definitely hope everyone's working together and let us know how it's going. From an advocacy perspective, letting us know any of the key stories of how these programs are affecting your communities. I want to remind everyone that this is being recorded and the slides are available, so please check that out. And if you have any questions, you can contact us and we'll be happy to answer your questions. We have time for one more question and then we will wrap it up. So we'll call this the final question. If the intending applicant is not receiving a state benefit, such as Medi-Cal out in California, Medicaid, and only the U.S. citizen spouse receives it, will the intending applicant be charged under the new rule?
So again, it's the benefits receipt by any other family member who's not an applicant for a green card will not be charged against the intending immigrant, the applicant. But that's not the whole picture. You got to look at all these other 5 factors to determine whether the applicant has enough income. That's going to be the most important determining factor.
All right. Thank you so much, everyone. I hope this was informative. Please let us know how it's going, and do keep checking Clinic's website and our social media accounts for updates if an injunction does in fact occur before next week. We thank you for your time, and please let us know how we can help going forward. Thank you.